Hey guys, what's up? It's the September 3rd Sarah Boone hearing. What are they going to do on September 3rd? Okay. So this is the motion for a new trial from Ashley Benefield. And I wanted to do a video on it because, well, this isn't a video, this is a live stream. Every time I tried to record it, something went wrong. Sound went wrong, video went wrong, font was crazy. I don't know, but it didn't work. So I decided to do a live stream. And the reason for this is because I live streamed her trial, and I've never watched a trial where I disliked all of the lawyers. So, and I know that people will disagree with me, because I've talked to some people that disagree with me. But I think at the time that the evidence viewing, okay. Do you know, is it gonna be streamed? Well, it doesn't matter, because what evidence they decide to use will be shown in the trial, so we won't miss anything, even if they don't stream that one. So the way I saw the Benefield trial was, no matter what she may have started off to do, she may have started off manipulating Doug and wanting to have sole custody and, wanting to just take off and be a single mom. That might have been her intentions in the beginning. It's very possible those could have been her intentions. But maybe she had a change of heart, because I think she was genuinely trying to get along with him and was going to move to Maryland and try to co-parent with him. I believe that. But I believe at that moment, I think she was in fear for her life at that moment. So I agree with him about some of these points in this motion for a new trial. However, I'm not a lawyer, so I don't know if the law that he's citing actually applies to the actions of the prosecutors. What I mean is, I don't know if the things that he's saying they did legally incorrectly, if it was actually legally incorrect. I hope I'm making myself clear. Like, does the law that he cites apply to the actions that they took? Were they illegal actions, or were they just distasteful actions? You know what I mean? So, and there is jury tampering on there. I'm not quite sure that that's jury tampering, though. So we'll talk about the jury tampering when we get to that part. Well, I don't have two screens set up, so if you guys ask me questions, let me get it set up on my phone so I can see your questions while I read. That's something else when I get my own studio set up. I'm going to have two screens set up, so it will be much easier. Okay. Now I've got my... No, I said pause. Okay. Pause. Now I've got my... Pause. There. Okay. No, there's somebody else. They're just there. See, that is what I said. Which, okay, when we get there. See, I wish I had two. Okay. State of Florida versus Ashley C. Benefield. Motion for new trial, request for interview of trial jurors, and incorporated memorandum of law. Ashley C. Benefield, by and through undersigned counsel and pursuant to the Sixth Amendment and the Due Process Clause of the 14th Amendment of the United States Constitution and Article 1, Sections 9 and 16 of the Florida Constitution, as well as Rule 3.600A2B2458 of the Florida Rules of Criminal Procedure, hereby moves this court for a new trial as grounds in support of the instant motion. Ms. Benefield alleges as follows. 1. Prosecutorial misconduct. The prosecutor's improper and inflammatory remarks during closing arguments prejudice Ms. Benefield's substantive rights and warrant a new trial. Oh, there's a lot about the rebuttal closing and a lot. A. Legal standard. Under Rule 3.600B of the Florida Rules of Criminal Procedure, the court shall grant a new trial if 5. The prosecutor was guilty of misconduct, or 8. For any other cause not due to the defendant's own fault, the defendant did not receive a fair and impartial trial. Rule 3.600B5 requires the court grant a new trial where the prosecutor is guilty of misconduct that prejudiced the defendant's substantial rights. State v. Connell. Improper prosecutorial comments warrant a new trial where they deprive the defendant of a fair and impartial trial, materially contribute to the conviction, are so harmful or fundamentally tainted as to require a new trial, or are so inflammatory that they might have influenced the jury to reach a more severe verdict than it would have otherwise. Spencer v. State. The defendant's substantive rights are prejudiced if there is a reasonable probability that, but for the remarks, the outcome would have been different. B. False statements about Douglas Benefield filing for sole custody. I don't know why they can't file these types of motions in Karen Reed. It seems like they should be able to file a bunch of motions in Karen Reed, but the thing is, Judge Bev would just throw them out like she does everything else. But this is what one of the things that I'm like, why didn't he just object at the time? He could have, I mean, it's not common to object during openings and closings, but it's allowed. So why didn't he object? All he had to do was say objection, facts not in evidence. And the judge could have said sustained. Jurors disregard that comment. I mean, false statements about Douglas Benefield filing for sole custody. During closing argument, Chief Homicide Prosecutor Suzanne O'Donnell falsely stated, and let me tell you, the grammar and the punctuation is just not here in these closing arguments. This is really hard to read. May 4th, only a few days later, after she files for another injunction, Doug files for sole custody of the child. This is Ashley Benefield's biggest fear, that this man is going to get sole custody, but she's making all of these grand allegations against him that he knows are not true. There's got to be something wrong, and it's probably not safe for this child to even be with her, so he files for full custody. This statement was entirely false and unsupported by any evidence presented at trial. In fact, the court docket shows that it was Ashley Benefield who filed a motion on May 4th, not Douglas Benefield. The prosecutor further emphasized this false claim in her PowerPoint presentation displayed to the jury. 9/2019, Doug finds out she's dating someone else. Doug files for divorce. Series of complaints start, no charges. 5/1/2020, defendant files for another injunction. 5/4/2020, Doug files for sole custody. Seeing multiple therapists. Forrest Quintal, defendant acts different in front of Doug. Social outings, beach, movies, restaurants, pool. 6/1/2020, sent for eval with Dr. Broder. Continues deception. Well, it's not their writing. This is like, well, that paragraph wasn't too bad. That one wasn't bad. The ones coming up, oh my gosh. I don't know if they're the exact transcripts from the trial, but like they're closing arguments and they're a mess. The improper argument implied the state had information not presented at trial, suggesting Miss Benefield was going to lose custody of her child, the final motive put forward by the state. Such comments referring to matters outside the record are clearly improper. See Wheeler v. State. As held in Williamson v. State, a prosecutor may not refer to facts not in evidence, as it constitutes a form of unsworn testimony not subject to cross-examination. Similarly, in Vexex v. State, I don't know how to say that word, and Lane v. State, the appellate courts held that it was improper for a prosecutor to refer to testimony or items not in evidence. So why didn't he just object? He could have just, at the time, objected. Facts not in evidence. Bada bing, bada boom, done. Sustained. Given the highly prejudicial nature of this false claim about Mr. Benefield seeking sole custody, there is a reasonable probability it affected the outcome of the trial. Moreover, the improper comments deprived Miss Benefield of a fair and impartial trial, materially contributing to the conviction, and were so harmful and fundamentally tainted as to require a new trial. Ms. O'Donnell's statement exceeded all acceptable bounds of advocacy and deprived Miss Benefield of a fair and impartial trial. A new trial is warranted on this ground alone. Yeah, that's what objections are for. I don't know that that alone, though, warrants a new trial. But reading on, although the prosecution is going to fight this like crazy. C. Improper attacks on and belittling of Miss Benefield's character and identity. The prosecutors repeatedly and improperly attacked Miss Benefield's character, calling her a manipulator at least 14 times during closing arguments, and claimed she was manipulating everyone, including the jury. They ridiculed her emotional testimony and accused her of lying without evidence. Such vituperative characterizations of a defendant are improper and prejudicial. There's my new word, y'all. Oh, well, let me highlight it. Oh, well, vituperative. It means bitter and abusive. For example, prosecutor Suzanne O'Donnell told the jury, the defendant trying to say he was in a fighting stance, he lunged at me. That is just her once again trying to manipulate the system. She's trying to manipulate you to believe that this was necessary. He was coming at me, but the physical evidence does not bear that out. It does not show that he was coming at her and that she had to shoot him. During the state's rebuttal closing argument, Assistant State Attorney Rebecca Friel told the jury, buying the house. I read that very differently. First of all, he wasn't trying to buy, he was trying to rent. What difference does that make? And if you don't believe that they were talking while they had this mutual injunction, they were, I'm sure. Miss Benefield was lying to him, telling him they're going to move to Maryland, live in separate houses, but, co-parent. And she was all the while planning with her attorney to have an injunction hearing in a matter of days. It's reasonable to believe that the mutual injunction was, I'm sure Miss Benefield was speaking to him when it was convenient for her, when she could get something out of it. It only goes with the rest of it. This letter we've heard about that Miss Benefield testified to about all these things. It's another effort at manipulation. We don't know when she wrote that letter. We don't know what she put in it. We don't know if any of it was true. I can write a letter and tell you that I'm the Queen of England. It doesn't make it true. And just because I say I wrote it 3 years ago doesn't mean I did. I keep saying manipulation, and the reason is because this defendant attempted to manipulate the system. It didn't work. She attempted to manipulate the experts. She kind of did, right? Because what did we hear about Dr. Liu and Mr. Haig? They talked to the defendant. She told him what she says happened, right? I don't even think she told them the same story she told you based on what they said. I would submit to you that those two experts, Mr. Haig was the one you should be depending on, even though he also spoke to Ms. Benefield, so clearly got one side of the story or a made up story. As to Dr. Broder, I think you should take some of what Dr. Broder said to heart. His concern, her concern, was not that Doug was going to fly off at the handle. She said she was concerned she would make him look bad in front of Dr. Broder. I pretended that I'm moving to Maryland and going to co-parent because I don't want to make him look bad. This man that I would have you believe was an abusive, horrible man. They have defamed him up and down. No, she didn't say that. She didn't say I was afraid that Doug would freak out on me. I was afraid he'd do this, so she said I didn't want to make him look bad. She's manipulating Dr. Broder, right? She's manipulating Doug for sure. It's manipulation, and that's what she does. That's what she's done. The evidence has shown it to you. I would submit to you that Ashley Benefield is very smart. She's been working the system or trying for years. And if I say, oh, I'm trying to co parent with an abuser, that looks good for me. He's an abuser. He shouldn't have my baby. He shouldn't have medical control. He certainly shouldn't have custody, partial custody, or anything else. Just because she said it doesn't mean it's true. And that's because, as I said, she tried to manipulate the system in South Carolina, ended up being mutual. She tried to manipulate the system in Florida. She got turned down. She tried to terminate his parental rights. The judge gave him custody. She tried to manipulate the experts, as I already talked, and I think in some cases she did, and she's trying to manipulate you. These inflammatory attacks on Miss Benefield's character served no purpose but to inflame the minds of the jurors against her. Such arguments are clearly prohibited. As the court stated in Chambers v. State, permitting this general attack on the defendant's character was error. The prosecutors also ridiculed Miss Benefield's testimony, with Miss Friel stating, "You can decide what you think about her testimony. She's a witness like any other." But I would submit to you that that was all manipulation. There were no tears. You use your common sense. If you cry and have to take breaks and you're racking, then you're going to have a swollen face. Your eyes are going to be puffy. You're going to have snot. I don't know what other word to use. She didn't even get a tissue until I can't remember who, either the judge or the defense attorney told her, hey, there's a tissue. Oh, yeah, I should have a tissue. She'd been crying for 15 minutes, didn't need a tissue. That's manipulation. That's her efforts to manipulate you and make you believe that she was a victim. She is not the victim. Douglas Benefield was the victim in this case. Such vituperative characterizations of a defendant are improper and prejudicial. As stated in Gore v. State, a prosecutor cannot engage in vituperative or pejorative characterizations of a defendant or needless sarcasm, revealing that the prosecutor has abandoned any semblance of professionalism. In the words of one viewer, these prosecutors sound like a couple of high school bullies. And I kind of agree with him. They were so unprofessional. I've never seen, I don't think that Judge White is going to grant a new trial. I don't think he's going to grant it. But I did not like those prosecutors. They were sarcastic, flippant. And the way Suzanne O'Donnell went after her by having her come down off of the stand, because like the fighting stance, and later in the motion it talks about how she mischaracterized the wounds. But a fighting stance, you're not straight one-on-one with somebody in a fighting stance. You're turned, and I did this during the trial too, because I cardio box, you're turned sideways. But you're not completely sideways. Like the bullet is not going to come in under here, like under your arm, under here. It comes in the front, and it came in next to his nipple. So it came in the front. He's martial arts. Was it Taekwondo? He's got a black belt in something. I think it was Taekwondo. So he didn't have fists. He had this. But so he's sideways, but to the front. So when she shot him, it went in the front and then went diagonally through his body to his back. So it went in the front and it lodged in his back. So she totally mischaracterized the attack. And then she has Ashley stand down off the stand, and she's trying to show how he was standing. And Suzanne O'Donnell's like, well, what did he do? Huh? What did he do? That was the most ridiculous thing I've ever seen a lawyer do in court. That was just so unprofessional. She was being a bully. No, it shouldn't be proper. Yeah, I didn't like that. I mean, I don't know if that grants her a whole new trial or not. I mean, but can't you object? Is there a ground for objecting on being a bully? I mean, could that have been argumentative? That could have been argumentative, right? I don't know. I'm not a lawyer. I'm just saying. I've never seen a lawyer make fun of a defendant like that before. Yeah. Because even if you're completely sideways and like this, well, you're facing somebody. But he wasn't completely sideways. He was like this. And lunging, you can still lunge when you're in a black belt. I'm sorry, you don't need to be armed. Badgering the witness, yeah. Black belts don't need to be armed to be deadly. That's why they're black belts. And I'm sorry, but I believe at that point in time, and I understand why the prosecution talked about all the other crap that happened, because they're mitigating factors. But I think at that particular time, she was afraid for her life. And I think if all that other crap had not happened, she would not have been found guilty. But that's my opinion. Still not enough, the prosecutors went even further and claimed Miss Benefield was lying with no evidentiary support. They said she told defense experts a made-up story, again without any basis in the evidence. Such attacks on the defendant's credibility are improper. As the court cautioned in Pacifico v. State, where the case against a defendant is weak or tenuous, a prosecutor's contentions that the defendant is a liar could rarely, if ever, be construed as harmless error. In Rosso v. State, the court held that improper prosecutorial comments will warrant a new trial where the evidence is very close, where a prosecutor refers to testimony or items not in evidence, or where a prosecutor indulges in personal attacks upon an accused, her defense, or her counsel. D. Improper speculation about out-of-court conversations. Prosecutor Friel engaged in improper speculation about conversations between Miss Benefield and Douglas Benefield, stating, first of all, he wasn't trying to buy, he was trying to rent, and if you don't believe that they were talking while they had this mutual injunction, they were, I'm sure. Miss Benefield was lying to him, telling him they're going to move to Maryland, live in separate houses, but co-parent. And the first time I read this, the first thing that popped in my head was, and I guess I don't remember if I thought about it when I heard her say it in trial, but the first time I read this, I was like, how does she know? How does she know she's lying to him about that? There is no evidence presented at trial that Miss Benefield and Mr. Benefield were communicating while the mutual injunction was in effect. The prosecutor's claim that they were, I'm sure, talking implies the state had information not presented at trial. Such arguments referencing matters outside the record are improper. E. False claims about defense expert testimony. The prosecutors made false claims about the testimony of defense expert Dr. Emma Liu. This, I remember at the time thinking, they're attacking expert witnesses. I don't think I've ever heard a prosecutor say an expert's findings were wrong like they did. And the way they did it, well, let me read the paragraph. Dr. Liu is a medical examiner. She seems like a well-qualified medical examiner who did testify mostly for the state because she worked for the state and is now testifying for the defense. And the defense asks you, why would she do that? She did that because she's getting paid to be here. That's why she's here. That's why she's saying those things. And most of them are probably very accurate. Getting paid. They all get paid. All of the expert witnesses get paid. That's what they do for a living. They're professional witnesses. That's what they do. There was no evidence presented that Dr. Liu was being paid to testify or that she testified the way she did because she was paid. Ironically, at the time of her testimony, and as this is being written, Dr. Liu has received no fee whatsoever. The prosecutors never even asked Dr. Liu if she was being paid. This improper argument suggested, without any foundation in the record, that the defense had suborned perjury from their expert witness. Such comments are highly irregular, impermissible, and prejudicial. Moreover, the prosecutors improperly denigrated the defense theory and expert witnesses. A prosecutor may not ridicule a defendant's theory of defense. In Rosso v. State, the court held that improper prosecutorial comments will warrant a new trial where the evidence is very close, where a prosecutor refers to testimony or items not in evidence, or where a prosecutor indulges in personal attacks upon an accused, his defense, or his counsel. Yeah, every time they rolled their eyes at Taylor, that was crazy too. F. Improper appeals to emotion and sympathy. The prosecutors made inflammatory arguments clearly designed to arouse the emotions and prejudices of the jury against Miss Benefield. For instance, Miss O'Donnell emphasized, I have thoughts on this too. Afterwards, she runs over to the neighbor's house. Not once do you hear her say, get an ambulance. I don't know if he's still alive. I had to do it but somebody help him. Not once did you ever hear any concern that I just shot another human being, regardless of what the facts are. No. And she was the only person armed in that room. Doug Benefield was not armed. He had no weapons. He was laying on the floor dying, and she goes to the neighbor and not once asks for an ambulance. And he dies either on the way to the hospital or in the hospital. She was the only one armed, and it was not necessary. She did not have to shoot him. It was not reasonable. She did not have to shoot him. She had an agenda, and it worked for what she wanted, and she got what she wanted. Because after she killed him, what did she get? Sole custody of the child. Now, let me ask you something. If there's an intruder in your house, whether you know them or not, whether you invited them over or not, and you think they're trying to kill you, are you going to bend down and see if they're still alive after you've shot them? No. You're going to get the heck out of there. And if you run to the neighbors and say, I was just attacked and I shot them, do you think your neighbor is going to make you a hot cup of tea and sit you down on the couch and have a, a conversation? No. What do you expect that your neighbor's going to do? Your neighbor's going to call 911 because you just told them that you shot somebody. Do you think she went over there thinking that an ambulance was not going to be called for him? I don't know what Suzanne O'Donnell thinks that Ashley thought was going to happen when she went next door to tell her neighbor that she just shot Doug. I mean, that's just right. Exactly. She didn't use the words call an ambulance, but if you tell somebody, I just shot someone, you don't expect them to ignore that statement and not call an ambulance. I mean, it's just ridiculous. It's just the stuff out of this woman's mouth. I swear. And that's what I thought a bunch of this during close. I can't remember if I said it, but I remember thinking a lot of this during closing. How ridiculous. Yeah, Sarah called 911. But like, I mean, it boggles my mind. What did they think? Why do they think she went to tell the neighbor what happened? Because she didn't know he was dead. She got out of there for her own safety because she had tried to get away from him first. She tried to leave, and he wouldn't let her out of the house. Such arguments that serve only to inflame the minds of jurors are improper. As held in Bertolotti v. State, closing arguments must not be used to inflame the minds and passions of the jurors so that their verdict reflects an emotional response to the crime or the defendant rather than the logical analysis of the evidence in light of the applicable law. In Guerin v. State and Gonzalez v. State, the courts held that arguments that have no purpose but to inflame the minds of the jurors against the defendant are clearly prohibited. See also Rosso v. State, discrediting a proper legal defense instead of commenting on the evidence and the reasonable inferences therefrom. Taylor v. State. Yeah, inferences like, I just shot Doug. Call an ambulance. That was the inference. Call an ambulance. G, improper burden shifting. This one I don't quite understand, because this is more law stuff than common sense, unless I'm just obtuse, which sometimes I am. So the prosecutors repeatedly misstated the law on self-defense, telling jurors they needed to evaluate whether Miss Benefield's use of force was reasonable and necessary. For example, Miss O'Donnell stated, "So the real question in this case is, was there self-defense? Was there justifiable self-defense?" And the self-defense instruction is long, and you'll have it to review in the back. However, what you will notice are two words that come up all the time in that instruction. Self-defense, justifiable use of deadly force would be: Ashley Benefield was justified in using deadly force if she reasonably believed such force was necessary to prevent imminent death or great bodily harm or a forcible felony. You're going to see those two words, and like I told you a little bit earlier, that's what you need to think of each time that you're trying to evaluate whether she used force appropriately. Ms. O'Donnell further shifted the burden of proof impermissibly in closing argument when she highlighted and emphasized the incorrect instruction in her PowerPoint presentation displayed to the jury. Self-defense, justifiable use of deadly force. Ashley Benefield was justified in using deadly force if she reasonably believed that such force was necessary to prevent imminent death or great bodily harm or a forcible felony. During rebuttal closing argument, Assistant State Attorney Rebecca Friel again argued, "A reasonable doubt does not mean proof beyond all doubt. You don't have to get back there and have no doubt. You have to get back there and decide, did she shoot and kill him with a depraved heart? And I would submit to you she did. And then you have to decide, was she justified in using self-defense? Was it reasonable and necessary based on what happened in that house that she shoot and kill him on September 27th, 2020? It's not a mere possible doubt, a speculative, imaginary, or forced doubt. That's not what we're talking about. We're talking about a reasonable doubt, and the state would submit to you that we have proven beyond a reasonable doubt that Doug Benefield is dead. The death was caused by a criminal act of this defendant, Ashley Benefield, and there was an unlawful killing by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life, and it was not justified. It was not based on self-defense. It was not reasonable and necessary to stand 6 to 7 feet away from that man and shoot at him 4 times. And I would ask that you come back and find this defendant guilty of murder in the second degree with a firearm." Didn't they say that was wrong? The 6 to 7 feet away. Didn't they say that was more like 3 feet? Wasn't that one of the arguments that they were making about the what's it called? I forgot what it's called. Not stippling, but is it stippling? Powder burns or whatever. Because they kept saying, prosecution kept saying 6 to 7, and defense kept saying it was closer, like 3 feet. This argument improperly shifted the burden to Miss Benefield to prove her actions were justified. The self-defense jury instruction clearly states Ashley Benefield does not have the burden of proving that she was justified in using deadly force. I thought the burden shifted when it was a self-defense case. I thought that was the only time it shifted to the defense, when it was self-defense. Maybe I need to talk to Alita about this. Man, I wanted her to do a live with me, but she just wasn't feeling up to it. Ashley Benefield does not have the burden of proving that she was justified in using deadly force. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using deadly force. As held in Brown v. State and Hernandez Ramos v. State, the state has the burden of proving guilt beyond a reasonable doubt, which includes proving beyond a reasonable doubt that the defendant did not act in self-defense and insanity. So why is he saying that? Then why is the instruction that she doesn't? The Florida Standard Jury Instruction. The state must prove beyond a reasonable doubt the defendant was not justified. Wait, is it different in Florida? Well, now I could email Peter, but he doesn't email me back, so I don't know why. Maybe he doesn't like me. The state has the burden of proving guilt beyond a reasonable doubt, which includes proving beyond a reasonable doubt that the defendant did not act in self-defense. A defendant has a fundamental right to present a defense, see Story v. State, and to have the jury properly instructed on any legal defense supported by the evidence, Gardner v. State. These rights stand for naught if the prosecutor can ridicule a defense so presented, denigrate the accused for her determination in raising the issue, and misstate the law in contradiction of the judge's instructions, as the prosecutor in this case did. The error committed by the prosecutor in closing argument, therefore, deprived Ms. Benefield of her fundamental right to a fair trial. With ample evidence to support the defense of justifiable use of force, it cannot be said that this error was harmless beyond a reasonable doubt. H. Oh, okay. This is the facing versus sideways thing. Yeah, because who was it that said, was it Alita? It might have been Alita. In Rittenhouse, they said that, because it's always this thing about are they going to take the stand in their own defense? And usually, they don't. And the lawyers don't want them to. But in self-defense cases, they kind of have to, because they have to tell their side of the story. They have to tell why, to them, like their mind, their, what do they call it? State of mind. Their state of mind at the time. They have to say why they felt like their life was in danger. So they have to take the stand to tell why it was self-defense. It's like if Kyle hadn't got up there and talked about, why he felt he needed to do what he did, he probably would have gotten guilty. The uncontroverted testimony was that the wound path of the fatal shot to the decedent's chest was from front to back, left to right. Such was the testimony of Dr. Vega, the state's medical examiner. That wound path description was confirmed by Michael Haig, the defense's ballistic expert, as well as Dr. Emma Liu, the defense's physician and just retired Miami-Dade County medical examiner. Despite that, and using a graphic illustration never at any prior time shown to the defense, the state, through Assistant State Attorney Suzanne O'Donnell, represented to the jury that the wound path was side to side. About this trajectory, just because there's some sort of misconception that this shot was front to back, that is just the planes with which the medical examiner uses, so it can be a little confusing. Yes. But if you look at the way this arrow is that the bullet goes in right by the right nipple and then lands right here. So it is side to side. Now, once it went in where the nipple is, did it curve a little bit to the back? Yes. Bullshit. Yes, that's why it's like in the back. That's why they say front to back. So it went side to side and a little bit to the back. There is no way he was facing her when she shot him. There's no way a bullet curved. No way. Here's another angle. This is from the back. So if it went in on the side, the right hand side, and that blah, blah, and that red dot is where it landed in the back. I don't know why I did not catch how ridiculous that was when I listened to it at trial. But that defies physics. Oh, those are just the planes the medical examiner uses. What? No, that's not how that works. You have front and back, and you have side, and you have side. If it goes in here, that's the front, Suzanne. That's not your side. That's your front. She needs an anatomy class, is what she needs. Oh, yeah, that judge. That judge was hilarious. Absolutely hilarious. There's somebody on YouTube. I don't remember whose chat I see him in most often, or her. I don't know. But the screen name is Don't Get Brazen with Me, and the profile picture is a picture of that judge. In an even more blatant misrepresentation, Miss O'Donnell used a graphic depiction to demonstrate that the wound path entered the decedent's right side, behind his right arm, traversed his chest in a straight path, and lodged in his back. How can it curve and be straight at the same time, Suzanne? This was a flat-out misrepresentation of uncontroverted testimony, which clearly misled the jury. Cumulative effect. While no single improper comment may require a new trial on its own, the cumulative effect of the prosecutor's numerous improper and inflammatory remarks deprived Miss Benefield of her fundamental right to a fair trial. As the court stated in Johns v. State, while no one of the comments standing in isolation would have required a new trial, this court must look at the entire trial record when considering whether the comments at issue are of such a nature as to destroy the fairness of the proceeding. When considering the relative lack of evidence against Johns, the character of the evidence that did exist, and the number of improper arguments made by the prosecutor, it is apparent that the prosecutor's closing argument was improper with respect to the neutral arena in which a trial should be held. As stated in Chambers v. State, in order to require a new trial based on improper prosecutorial comments, the prosecutor's comments must either deprive the defendant of a fair and impartial trial, materially contribute to the conviction, be so harmful or fundamentally tainted as to require a new trial, or be so inflammatory that they might have influenced the jury to reach a more severe verdict than it would have otherwise reached. The prosecutors in this case repeatedly made inflammatory and improper comments attacking Miss Benefield's character, referencing matters outside the record, making false claims about the evidence, appealing to sympathy, and shifting the burden of proof. Given the nature of the evidence in this case, these inflammatory and improper comments affected the outcome, deprived Miss Benefield of a fair and impartial trial, materially contributed to the conviction, and were so harmful or fundamentally tainted as to require a new trial. As held in DeGilio, to establish harmless error, the state must show beyond a reasonable doubt that the error complained of did not contribute to the verdict, or alternatively stated that there is no reasonable possibility that the error contributed to the conviction. The state cannot meet that burden here. A prosecutor's concern in a criminal prosecution is not that it will win a case, but that justice shall be done. While a prosecutor may strike hard blows, she is not at liberty to strike foul ones. The prosecutors in this case clearly failed to honor these precepts. Their conduct also violated the obligations imposed by the Florida bar. In short, the prosecutors exceeded all acceptable bounds of advocacy. It is appropriate here to reiterate the jurisprudential principle expressed in Pacifico that the cornerstone of our system of justice is the right of an accused to be judged fairly by a jury of his or her peers. On the record in this case, the repetitious and egregious nature of the prosecutorial improprieties became such a feature of the trial as to deprive Miss Benefield of that fundamental right. In this regard, the state cannot demonstrate beyond a reasonable doubt that the prosecutor's comments impugning Miss Benefield and her defense did not contribute to the verdict. Finally, in this case, the prosecutor's reference to Miss Benefield as being a liar, a manipulator, and to matters for which there is absolutely no support in the record in a manner both pejoratively and sarcastically, all of which form the basis for Miss Benefield's motion, were so invasive and inflammatory, it is questionable whether the jury could put aside the prosecutor's character attacks, excuse me, and decide the case based strictly upon the evidence. Thus, in situations where witness credibility is the pivotal issue, inappropriate prosecutorial comment, which might be considered harmless in another context, can become prejudicially harmful. As emphasized in Bass v. State, when the case presents a two-witness swearing match where there is little or nothing to corroborate the testimony of the witness, witness credibility is pivotal, and inappropriate prosecutorial comment, which might be found to be harmless in another setting, may become prejudicially harmful. Because the present case chiefly involved the testimony of Miss Benefield, the undeniably crucial issue was the juror's perception of Miss Benefield's credibility. Okay, so that's the first part. That's the first part of the motion for a new trial. So, what do you guys think? I don't think Judge White is going to grant it, just because I don't think he's going to grant it. But I don't disagree with Taylor, because I did not like the way those prosecutors acted. They reminded me of Mean Girls. Like, they were the mean girls in high school. They acted to me more like, I don't know, maybe it was because, I don't know, maybe because they were female and she was female. Maybe that's why I got that vibe. It's like, it felt like a personal thing. It just felt like, like a mean girl thing. Like they didn't like her and they wanted to do something about it. I mean, I might be totally missing the mark on that, but I didn't like them. And I've never felt that way about a prosecutor before. Like, I've not liked prosecutors, but not because of that. They were just like really, really, they just seemed unprofessional to me. And that's why I wanted to do this with Alita, because I would like to know legally if any of these, like the cases he cited and stuff for this, if that, because for instance, like you take a soft sit, they will spout off all these cases to to dang it, what's the word I want? To plead their case. Like this applies to this, like the traveling thing. Dear Brooks. Yeah, this case of the Supreme Court, this is why I can travel, whatever. And then the judge is like, that doesn't apply to that. That's not what that means. And I know that lawyers know that what the law means. But I want to know how much that a law does a law that he cited, does what they did, is that actually what that case that he cited means? Do you know what I mean? Like, did they overstep? Did what they did, was it actually illegal to the point that she needs a new trial? Or were they just being, you know, close to the line? You know what I mean? Like I want a lawyer's opinion on whether they cross the line or not, I guess is what I'm saying. Now the next part is definitely, I don't know though. I think it almost seems like this is being given more weight than the first part, because there's actually going to be a hearing. No, they didn't bring up subject matter jurisdiction. Okay, so the next part is identifiable juror misconduct. Juror 15, Sarah Yvonne Walcott, failed to disclose on her questionnaire material information and further concealed material information during voir dire that would have resulted at a minimum in preemptory challenge by the defense. A. Legal standard. The Florida Supreme Court has laid out a 3-part test for determining whether a juror's non-disclosure of information during voir dire will warrant a new trial. First, the complaining party must establish that the information is relevant and material to jury service in the case. Second, that the juror concealed the information during questioning. Lastly, that the failure to disclose the information was not attributable to the complaining party's lack of diligence. While De La Rosa is a civil case, the Florida Supreme Court routinely applies its 3-part test in criminal cases. Any juror who conceals a material fact that is relevant to the controversy is guilty of misconduct, and this misconduct is prejudicial to at least one of the parties because it impairs his or her right to challenge the juror. In criminal cases, of course, the state is also a party. The presumption of prejudice has been said to apply unless the opposing party can demonstrate there is no reasonable possibility that the misconduct affected the verdict. Under the rule, a criminal defendant is entitled to a new trial if a juror's misconduct has prejudiced the defendant's substantial rights. The substantial right implicated in this case is Miss Benefield's right to be tried by 6 impartial jurors and her right to challenge a juror for cause or make a peremptory challenge. Thus, is the duty of a trial court to see that the defendants in criminal cases are tried by a jury such that not even the suspicion of bias leaning, or prejudice, prejudgment can attach to any member thereof. If there is any reasonable doubt as to whether a particular juror can render an impartial verdict based solely on the evidence presented and the law announced at trial, that juror should be removed, even if the juror affirmatively states that he can be partial. While challenges for cause permit rejection of jurors on a narrowly specified, provable, and legally cognizable basis of partiality, the preemptory permits rejection for a real or imagined partiality that is less easily designated or demonstrable. I'm so glad I didn't become a lawyer. I almost did. Once Ms. Benefield has established juror misconduct, she is entitled to a rebuttable presumption of prejudice and thus a new trial. However, I'm sure a layperson reading a medical book would probably think the same thing because I can read a medical book and I couldn't before I became a nurse. I imagine they teach lawyers how to read this stuff, so they cut through it just like a hot knife through butter, like I do a medical book. What would a defense attorney Deb be like? I don't know. I don't have the backbone to be a lawyer. The harmless error analysis places the burden on the state as the beneficiary of the error to prove beyond a reasonable doubt that the error complained of did not contribute to the verdict, or alternatively stated that there is no reasonable possibility that the error contributed to the conviction. B, the concealed information was relevant and material. Now, this ticks me off, but I don't know what you can do about it in hindsight other than a new trial. But I don't know if this had anything to do with the conviction or not. The information concealed by juror 15 is highly relevant and material to the case. It is. As the Florida Supreme Court has noted, relevance and materiality necessarily turn on the facts and circumstances of each case. The Fifth District Court of Appeal has explained that a juror's non-disclosure of information during voir dire is considered material if it is so substantial that, if the facts were known, the defense likely would peremptorily exclude the juror from the jury, and she should have been excluded. Juror 15 failed to disclose and or otherwise concealed the fact that, 1, she was a victim of domestic battery on February 20th, 2016, when her live-in boyfriend, Albert Ballinger, intentionally slapped her in the face with an open hand 5 times. 2, her son, Hayden J. Walcott, was charged with felony battery against his pregnant girlfriend on August 31st, 2014. And juror 15 was the bond depositor in this case. And 3, she was the respondent in multiple petitions for injunction for protection against domestic violence filed by her ex-husband, Charles D. Walcott, seeking protection for himself and their minor child. Wait, is the minor child? Oh. Well. What date? On grounds similar to those put forth by Miss Benefield against the deceased, Doug Benefield. Okay, so when this kid, the one that battered his pregnant girlfriend when he was a kid, apparently his mom, who was juror 15, had DV charges. Like, his mom had a petition for protection against her for doing DV against him and his dad. Specifically, 1. Juror 15 was a respondent in a petition for injunction for protection against domestic violence filed on September 2nd, 2003 by her ex-husband, Charles D. Walcott, seeking protection for himself and their minor child, HJW, in the 12th Judicial Circuit Court in and for Manatee County. Why couldn't they look that up? It's the same county. A copy of Mr. Walcott's petition is attached and alleged in part. Why didn't they know this? It's the same county. Would I be aggressive like Leslie Abramson? No. I think if I had become a lawyer, I wanted to be a prosecutor. Now that, like, I wanted to get into, after I became a nurse, I wanted to get into being a legal nurse consultant, which is where you basically, it's your own business and the lawyers are your clients, and you read like for cases involving medical stuff like wrongful death, like with nursing homes and hospitals and that kind of stuff. Like, you read the charts and you explain to the doctor what's in the chart. Like, remember with Johnny Depp, when Rottenborn was reading like medical stuff, he was reading them wrong. And I was like, why don't they have a legal nurse consultant? Because he's reading all this stuff wrong and it's not making a bit of sense. I was correct. I was screaming at the TV, correcting him because he was getting so many things screwed up. And so after I was going to do that, and then I was thinking about maybe after that going to law school to work kind of like Peter does, like malpractice or wrongful injury type stuff. But then I ended up going on disability because of the fibromyalgia, so I didn't get to do any of that stuff that I wanted to do. So, okay. So, yeah, so this was in Manatee County. There's the case number for this in 2003. So why didn't they know about this? I guess they don't do like background checks, but wouldn't it have been easy to look and see if the jury had any domestic violence history? So the petition alleged, in part, threatening and violent behavior by juror 15, including cussing, slamming doors, and throwing objects. A suicide attempt by juror 15 on unalive attempt, by juror 15 on July 18, 2003, resulting in hospitalization. Constant harassment and threats to Mr. Walcott and his wife. Fear that juror 15 might harm their son in a future self-unalive attempt. Request for supervised visitation until juror 15 demonstrated mental and financial stability. 2. Juror 15 was also a respondent in another petition for injunction for protection against domestic violence, filed on April 23, 2004 by her ex-husband, Charles D. Walcott, seeking protection on behalf of their minor child, HJW, in the 12th Judicial Circuit Court in and for Manatee County, Florida. A copy of Mr. Walcott's second petition is attached, and alleging in part physical abuse of the minor child by juror 15, including picking up the child by the arm, and slamming him against a wall. The child expressing fear of returning to juror 15's home. A child abuse report filed with the Bradenton Police Department. Threats by juror 15's boyfriend to kill Mr. Walcott. An ongoing Child Protection Services investigation. The child showing signs of becoming violent. Well, hello, that certainly happened. These undisclosed facts are strikingly similar to the prosecution's theory against Miss Benefield and would have raised serious concerns about Juror 15's ability to be impartial. The domestic violence allegations against Juror 15, including claims of threatening behavior, violence against a child, and concerns about mental stability, mirror key elements of the state's case in this instance. See, like, as Emily D. Baker says, you can't put the poop back in the horse. There's no way to fix that but to have another trial. But you got to kind of prove that the verdict would have been different if she hadn't been on the jury. And how do you prove that? As noted in Fine v. Shands Teaching Hospital and Clinics, I used to work for Shands Teaching Hospital. The focus should be on what appellant's counsel would have done during voir dire had the litigation history of the jurors been disclosed, rather than on whether the court believes the jurors were actually biased. Given the parallels between Juror 15's concealed history and the facts of this case, this information implies a bias or sympathy from the other side, which in all likelihood would have resulted in the use of a peremptory challenge. The defense would have undoubtedly exercised a peremptory challenge to remove Juror 15 had this information been disclosed. Hey, Aviva. Oh, yes, Flash fan. You should become the next Johnny Cochran. Yes. Yeah, I don't think that's normal protocol. But wouldn't it be easy just to look through the cases, at least in that county, to see if any of the jurors had just look at domestic violence cases, since that's what the case is about. I'm not saying like do a giant deep dive on background of the jurors, but if you just do domestic violence cases, I mean, it's gonna if they could figure out some way to do a background check, like a cursory background check, not like a deep dive, it would keep stuff like this from happening. It might even require like having a new position made at the courthouse, like someone that's all they do is like do background checks on jurors. But if stuff like this keeps happening, it might be worth something looking into. I guess that was a good attorney because he got her off and she did it. Hey, I'm glad you're back. Yeah. I said a dirty word earlier, but I did it into my hand. Because that was the most ridiculous thing I've ever heard. Like, she's delusional. She is delusional if she thinks that a front and back plane is just something that a medical examiner uses. Bodies have 4 planes. 4? 6. Yeah. Anterior, posterior. Yeah. Front, back, side, side. Top and bottom. I forgot the scientific-y names. Scientific-y. You can tell I haven't nursed in a while. Anterior, superior, posterior. Posterior's back. Superiors, I don't know. I don't remember all the big words anymore. Well, I don't like the judge in that case. We are getting way off the topic. Last night, I've told you guys that I have a little bit of a problem with depression. And last night I was feeling kind of bummed. And I was like, why? Why am I feeling so bummed out? What's going on? And then I figured it out. Because we were done with the Danny Rolling trial. And I have so looked forward to getting up every morning and live streaming with y'all. No, because I watched a show. I can't remember the name of the show, but it was Nancy Grace and Dan Abrams. And it was a show where they were taught, and I don't remember what streaming service it was on, even. But they were talking to juries and judges about verdicts that they had made and would they change their minds. And none of them said that they would change their mind. And they talked to the Casey Anthony jury, not the whole jury, but several jurors and the judge. And the judge said that she didn't kill her on purpose. She killed her. He admitted she killed her. But she didn't kill her on purpose. And Nancy Grace was just livid. But she chloroformed her so she could go out and party. And the judge said, yeah, and she'd done it before and everything was fine. That's child abuse. You can't do that. That's illegal. So when someone dies while you're committing a crime, that's felony murder. And she got off scot-free for felony murder. And that judge was like, but she didn't mean to kill her. So what? That's child abuse. That makes it felony murder. And so I agree with Nancy Grace 100% on that. And I don't know where he got that argument from. I don't know. But that's what he said. And I've not seen her trial. I've not seen him on the bench. That's the only place I've ever seen him. That's the only place I've ever seen him. So I don't know anything about the man or anything. I just know that I saw him say that on that show. And I was like, what? Oh my God. She didn't mean to kill her. She does. Now, I also watched on Nancy Grace's YouTube about Karen Reed, and she thinks Karen Reed is absolutely guilty. And I was like totally upset with her about that. But Nancy Grace had a fiance that was murdered when she was younger. And I think and they never found who killed him. And I think that kind of overshadows her thinking sometimes. So, but, and in that show, she said, she was talking about how when he first didn't come home, how she was saying, could I have hit him? Did I do this? And Nancy Grace said something about her husband. They couldn't find him one time, and he had gone on a business trip. And when he got there, he didn't call her, and he always called her when he got to where he was going on a business trip. And so they couldn't find him, and I don't know what happened. He missed his flight or something. I don't know. And she was like, my first thought was, did I do this? Am I the reason he's missing? That's apples and oranges. He was going away somewhere on a business trip, flying on a plane. Of course you're not going to think, did I do this? Like, her argument didn't even make any sense. Yeah, she pretty much is aligned with the prosecutor on cases. But I agreed with her in the Casey Anthony case. That was okay. So we're getting off track. Let's go back. Okay. The juror concealed the information during questioning. Juror 15 concealed this information both on her jury questionnaire and during voir dire. On the questionnaire, completed under penalty of perjury, she falsely indicated that neither she nor a family member had been a victim of a crime. During voir dire, when asked about child custody issues, domestic violence, and involvement with injunctions, Juror 15 remained silent. The Florida Supreme Court has held that a juror's non-disclosure need not be intentional to constitute concealment. Well, that was intentional because she knows that all that stuff happened. Whether intentional or not, Juror 15's omissions prevented counsel from making an informed judgment, which would in all likelihood have resulted in peremptory challenge. And two, if you're embarrassed, like if you don't want in open court everyone to know that like you've had injunctions filed against you, you can ask to talk to the judge privately and say, I've had injunctions filed against me. After my husband and I divorced, I kind of went a little crazy. And, you can tell a judge that and they'll say, okay, well, you're excused. And no one has to know why you're excused for the jury. So if it's a matter of being embarrassed, that's your solve right there. So that's not an issue. D, failure to disclose was not due to lack of diligence. The defense exercised due diligence in questioning potential jurors. Both the state and defense asked sufficiently specific questions about child custody, domestic violence, and injunctions. These topics are within an average juror's understanding, and Juror 15's failure to disclose cannot be attributable to any lack of diligence by the defense. As stated in Bowling v. State, the test for juror competency is whether the juror can lay aside any bias or prejudice and render a verdict solely on the evidence presented and the instructions given. If there is any reasonable doubt about a juror's impartiality, the juror must be excused for cause. Here, the concealed information is highly relevant and material to this case, was clearly concealed during questioning, and the failure to discover it was not due to any lack of diligence on the part of the defense. The similarities between Juror 15's undisclosed experiences and the facts of this case create a substantial likelihood of bias or sympathy, or a real or imagined partiality that would have resulted at worst in a peremptory challenge, if not for cause, had the information been disclosed. Okay, so Like I said about that one, there's no way to fix that other than a new trial. But they're going to have to prove that affected the verdict somehow. And I don't know how you do that. Unidentifiable jury misconduct. This one I don't think is gonna move the needle at all. Lastly, although not yet traceable to an identifiable juror, upon information and belief, an as yet unknown juror brought a cell phone into the jury room and used it during deliberations, constituting an objective act that compromised the integrity of the fact-finding process and prejudiced Ms. Benefield's substantive rights requiring a new trial. A. Facts. During deliberations, a juror brought a cell phone into the jury room and used it while discussing the case with other jurors. This act was in direct violation of the court's instructions and Florida law prohibiting unauthorized materials in the jury room. During jury deliberations, a YouTube user, that hoodie guy, posted comments on the Law and Crime Network's YouTube live stream of the verdict watch. These comments contained real-time information that could only have originated from within the jury room, suggesting a breach of the court's instructions, the sanctity of jury deliberations, jury sequestration, and Ms. Benefield's right to a fair trial. The comments posted on July 30th, 2024 reveal 1. At 2:20 p.m., 10 minutes before the parties were notified that a verdict had been reached, that hoodie guy posted a comment stated, "Verdict incoming." 2. At 10:25 p.m., that hoodie guy posted a comment stating, "Per sources, 5-1 guilty with the man stuck on not guilty or manslaughter." 3. At 10:27 p.m., that hoodie guy posted a comment stating, "My sister snuck a flip phone in." 4. At 10:28 p.m., that hoodie guy posted a comment stating, "I am the brother of one of the jurors. She just texted me this. Per sources, 5-1 guilty with the man stuck on not guilty or manslaughter." 5. At 10:28 p.m., that hoodie guy posted a comment stating, "My sister snuck a flip phone in. She texts me 5-1 guilty, may compromise on manslaughter." At 10:30 p.m., a mere 2 minutes after that hoodie guy posted that the jury may compromise on manslaughter, the jury entered a compromise verdict of manslaughter. The timing and specificity of these comments, followed by corresponding jury action, strongly suggest that hoodie guy's information originated from within the jury room during active deliberations. Accordingly, Ms. Benefield has formally requested the court interview the jurors in the presence of the parties. B. Legal standard. Under Florida law, a new trial could be warranted if the jurors considered unauthorized materials affecting their verdict. Furthermore, juror misconduct gives rise to a rebuttal presumption of prejudice. Once Ms. Benefield has established juror misconduct, she is entitled to a rebuttable presumption of prejudice and thus a new trial. Unless the state can demonstrate that any prejudice was harmless, the harmless error analysis places the burden on the state as the beneficiary of the error to prove beyond a reasonable doubt that the error complained of did not contribute to the verdict, or alternatively stated, that there is no reasonable possibility that the error contributed to the conviction. Although certain acts, for example, private communications, contact, indirect or direct tampering with a jury, raise a presumption of prejudice, not all misconduct raises the presumption. If the misconduct is such that it would probably influence the jury and the evidence in the cause is conflicting, the onus is not on the accused to show she was prejudiced, for the law presumes she was. Not all misconduct, however, will vitiate a verdict, even though that conduct is improper. It is necessary to show that prejudice resulted or that the misconduct was of such character as to raise a presumption of prejudice. In other words, potentially harmful misconduct is presumptively prejudicial, but the defendant has the initial burden of establishing a prima facie case that the conduct is potentially prejudicial. C. Cell phone during deliberations constitute juror misconduct. The presence and use of a cell phone in the jury room during deliberations is a clear instance of juror misconduct. In Tampere v. State, the court held that using a smartphone to access information not presented at trial was equivalent to bringing unauthorized materials into the jury room. The court stated a dictionary is not one of the materials permitted to be taken into the jury room. A cell phone, by extension, a cell phone, which provides access to vast amounts of information beyond that presented at trial, is equally impermissible. D. Integrity of the fact-finding process compromised. The use of a cell phone during deliberations constitutes an objective act that compromised the integrity of the fact-finding process. As noted in Tampines, some objective act must have been committed by or in the presence of the jury or a juror which compromised the integrity of the fact-finding process. The presence and use of a cell phone undoubtedly meets this criterion as it provided the jury with potential access to extraneous information not presented at trial. E. Presumption of prejudice. Under Florida law, once juror misconduct is established, there is a rebuttal presumption of prejudice. The burden then shifts to the opposing party to demonstrate that there is no reasonable possibility that the juror misconduct affected the verdict. In this case, the presence and use of a cell phone during deliberation creates a probability that the juror's decision-making process was influenced by unauthorized information. Unlike the automobile magazines in Hamilton v. State, which were deemed irrelevant to the legal and factual issues of the case, a cell phone provides potential access to a wide range of information directly relevant to the case at hand. Wherefore, Ms. Benefield prays that following an evidentiary hearing wherein the court recalls the jury and allows them to be questioned by the parties, the court grant her motion for a new trial. Respectfully submitted, Neil G. Taylor, Esquire. So, but you know what? It's been a long time since I've had a flip phone. But if I remember correctly, they don't have Wi-Fi. They don't. Mine only played Snake. That was the only thing. The only thing that's true. Remember that Snake game? That was the only thing mine had on it other than phone. I mean, I guess you could text with it too, but that was it. Texting and Snake. And there is another motion. I think from the state. Motion to strike defendant's motion to interview jurors. The state of Florida, represented by Ed Brodsky, state attorney for the 12th Judicial Circuit, files its motion to strike defendant's motions to interview jurors and would state as follows. The jury reached a verdict in this case on July 30th, 2024. The defendant filed this motion to interview jurors pursuant to Rule 3.575 on August 9, 2024, which appears to be timely filed. However, defendant's motion is legally insufficient as matter of law because the motion has made no sworn allegations as required by the Supreme Court of Florida. noting that juror interviews are not permissible unless the moving party has made sworn allegations that, if true, would require the court to order a new trial because the alleged error was so fundamental and prejudicial as to vitiate the entire proceedings. Additionally, even if the allegations were sworn to, the defendant has failed to allege specifically how these allegations, if true, were so prejudicial as to vitiate the entire proceeding. Juror interviews are unnecessary when an unreasonable allegation of juror misconduct is made, and the defendant fails to allege facts establishing a prima facie argument for prejudice. The facts and arguments in defendant's motion do not establish prima facie argument for prejudice. The motion merely alleges that, if true, these behaviors are violations of a juror's sworn duty, or that generally the behaviors impacted the fairness of the proceedings. Without more, these allegations are merely speculative and conclusory. In addition to the general insufficiency of the motion, the defendant has utterly failed to allege any juror misconduct pertaining to Juror 15's nondisclosure of being a previous respondent in an injunction. The motion fails to allege how the juror misrepresented these facts, whether by questionnaire or jury questioning. It should also be noted that no official transcript of the jury selection process has been released. The state has requested a transcript, but it is not available yet. So, how did your flip phone get run over by a truck? So the judge set a hearing for this. Don't remember what day. You are hereby notified that a hearing has been scheduled as follows. Request for interview of trial jurors filed A924 and motion to interview jurors filed A924 for a status conference hearing. Judge Stephen M. White, Monday, September 16th, 45 minutes at 1:30. So this is the hearing about having a hearing. So they're going to discuss whether or not they're going to have a hearing to interview the jurors. And Judge White signed it, but he didn't put the date. So I hope they stream it. If they stream it, I'll live stream it. Monday, September 6th. I have a doctor's appointment that day. Oh, but my doctor appointment's in the morning. It's at 1:30. So, okay. I need to put that on my calendar. How does that make a truck run over your flip phone? Did you throw it out in the street and a truck ran over it? I used to have anger issues too. Okay. Well, that's it for that. Yeah, I don't think she's going to get a new trial. And I feel bad for her. I still say at that moment, I'm not denying that she did the other stuff she did. I mean, my brother had a bad divorce with his wife and custody garbage and crap. it happens, but I don't know. I've not covered any of the Sarah Boone stuff because I thought Alita was going to do it. So, see, here's the thing. I just wanted to be a little bitty true crime channel. I wanted to get monetized eventually, but I just wanted to be a little bitty true crime channel. And then Meg taught me how to live streams. And then Alita didn't do the Black Swan, the Ashley Benefield. And so I thought, well, let me do that. That sounds like fun. And I thought it was just going to be like a one and done. And then, let me show you. I will show you what happened. Come on, Lou. What, dude? Your nose is cold. Why are you sticking your cold nose on my leg? Oh. 927 more than usual. 176 or 0.9 more than usual. That happened. So I was like, oh, I need to live stream. No, I'm just not talking into the mic. Can you hear me now? Can you hear me now? I was like, oh, I need to live stream. That's what I need to do. I was like, the green arrows. I have green arrows now. The the Danny Rolling streams, because after I did Ashley Benefield, because like I like live streaming, but I don't want to step on anybody else's toes. Plus, I'm not a lawyer, so I don't know. I can't answer any legal questions or anything. I don't want to take anything away from any of the lawyers. And I don't feel like I have any business live streaming a trial because I don't know anything. But then I looked at Brandy Churchwell and Recovery Addict and the other people that aren't lawyers and do it. And I thought, well, they're not lawyers. So, and one day we were on Bike Club and I was like, oh, I just had an idea. I could live stream the trials of like when I do a true crime video, if like Court TV has their trial in the archives, I could live stream their trials. True Crime South? I don't know what that is. And Alita said, "That's a good idea. That's a really good idea." And so I started with Danny Rolling just because it's Danny Rolling and it's Gainesville. So, and the trailer, I was trying to make a trailer like Alita did with the Menendez brothers. So that's and then I got to thinking about it and I thought other ones are it's going to be really hard to make a trailer for. Cuz that one was really easy because I did all of the places in Gainesville and all, but cuz I'm from, I know Gainesville. I did the swamp, the football field we call the swamp, and the museums and the colleges and all that. So I'll do more of those. I'm trying to think. I think I did a video on Rebecca Schaefer, the actress that got killed. She was waiting for a script. There was this guy, I think his last name's Pardo. She was waiting for a script, and this guy had been stalking her and bothering her and sending her letters and presents and stuff. But oh, okay, Robert Bart. Okay, I did a video on him, and I think I saw him on Court TV's archives. So I might do his eventually because I did do a video on that one. She was waiting for a script, and when the doorbell rang, that's what she thought it was. So she just ran downstairs to get the script, and he shot her. Oh, it's a bench trial? Cool. Yeah, so I might do that one. I want to do really, really bad. I wanted Alita to do it so we could all watch it together. Betty Broderick. But I want to do a video on her first. But it says it's a retrial. So I need to do a video on her because I didn't realize she got 2 trials. That lady's nuts. She is nuts. Pam Hupp is another one that I want to do, but I don't know if I can find her trial anywhere. I've seen like bits and pieces of it on different videos about her. But yeah, I got a whole list of stuff I still want to do. I just want my studio. I've got a whole room in there that's full of nothing but junk that her first trial ended in a mistrial. I don't know why. When I was doing episodes that to line up with Criminal Mind cases, there was a Dahmer one I was going to do. And that episode gives me the heebie-jeebies every time I watch it. And the person that plays the unsub on that episode, the bad guy, is Jamie Kennedy. And I love Jamie Kennedy. And I hate seeing him in that role. I've got a thing about that I can't even say the word, the C word. It just grosses me out so bad. That's like the one, I mean, I can handle other stuff, even, devastatingly disgusting other stuff, but that is the one thing that just I can't take. I can't. can't take it. I can't even say it. I can't take it. It makes me sick just to think about it. Can't. Okay. Well, I was like, no, I'm not gonna do OJ, that will take forever. Oh, I don't want to go, but I don't have anything else to talk about. Well, I need to get to work on my Sarah Boone video. I will talk to y'all later. Thank y'all for hanging out with me. It has been fun. And I will see y'all later. Bye. Take it easy. Have a good afternoon.